Welcome to everyone who's joined us. We are talking about assumption of responsibility in construction projects, with some emphasis within that on claims founded in tort. So I'm Ben Hardiman, I'm a partner in our insurance dispute service line, and I'm joined today by my colleagues Sophie Briggs and Neusha Mazaher, both of whom specialise in construction disputes. Just before we get going, I'm sure many of you will have been on a Mills Reeve webinar before, so just a bit of housekeeping. We are recording the session. It will be made available to view later. And of course, if you've got any questions, feel free to pop them in the Q&A box, and we will endeavour to address as many as we can today on the webinar. If we can't, we will also do our best to follow up and drop you a line. So what we're here to talk about today, we're looking at assumption of responsibility and the implications for construction claims. Now, a claimant may want to consider which parties can be argued to have assumed a responsibility to them, usually in circumstances where something's gone wrong and they're looking to obtain some form of remedy or compensation. Now, assumption of responsibility is a really broad and complicated area, and there are lots of ways in which a claimant may want to or may be able to argue that another party has assumed responsibility to them, depending on the facts and the circumstances. So, for example, you may have a party who doesn't have a contractual relationship. So, for example, a subsequent purchaser of a building and the original design and build contractor. Alternatively, you may have someone who suffered a personal injury at a site in circumstances where they may well have had nothing to do with the construction operations. Equally, you may have something a bit closer where you have a party who may have been able to bring a claim in contract, but that claim is now statute barred, and so they may well be needing to look for an alternative cause of action in order to obtain compensation. Now, we're not going to have time to go through every single one of these areas today. If there are any areas we don't touch on, please do fill in the feedback at the end. We will be more than happy to pick up in due course in future webinars. So what we're going to focus on today are the assumption of responsibility both within a contractual relationship and also where there is no contractual relationship, but where an assumption of responsibility may occur. So let's take the former position, perhaps the more straightforward. I'm going to ask Sophie, how do parties normally assign responsibility in construction projects?
So construction is a sector where there are usually a number of companies involved in any one project, and that might include an employer, the contractor, the architect, structural engineer, and potentially a range of other specialists, even in a reasonably simple project. So usually the relationship between those parties is governed by various contracts, subcontracts or collateral warranties, and they'll often take standard forms such as JCT or NEC contracts. So the simplest way to establish the duties or obligations another party owes to you is to have that written down in a contract, and it's worth taking time and seeking advice to make sure the contractual position reflects the position on the ground. If there's no contractual basis for one party to assume a responsibility to another, the courts are reluctant to fill that gap. So that was emphasised in the case of Henderson and Merit syndicates, where Lord Gough stated that the existence of a contractual chain which has been structured so as not to include a contract between the claimant and the defendant will commonly prove inconsistent with the duty of care arising between them.
Okay, well, the existence of a contract is normally going to mean that people at least know where they stand. But let's assume there isn't that contractual link between the claimant and the party responsible for loss. Sophie, what are the claimant's options in that situation?
So it really depends on the situation. In a design and build contract, a contractor may have taken contractual responsibility for the design and or work that's been carried out by subcontractors. So in that situation, it might be appropriate for the claimant to start a claim against the contractor, and then it would be for the contractor to pass that claim down the chain to the subcontractor. However, if the main contractor has not contractually assumed responsibility for the negligence of its subcontractors, then there's no general assumption of liability in tort, unless during the course of supervising the subcontractor's work, the main contractor becomes aware that it's being done in an effective or foreseeably dangerous way. And then if the main contractor condones that work and doesn't ask for the subcontractor to remedy it, then the main contractor might be liable for the consequences. If there's no contractual link, the claimant might seek to establish that even without contractual responsibility, a consultant or subcontractor owes the claimant a duty of care, and as such should be responsible for the loss or damage caused. So it might be, depending on the loss or damage, that a duty is established in statute. So for example, under the Defective Premises Act 1972 or under the Building Safety Act. And if you need more information on that, we've done a number of other webinars that cover that topic. If the loss is alleged but is not covered by a breach of contract or a statutory duty, then the claimant may need to try and establish the other party assumes a responsibility to them in tort.
Okay, so moving on to tort. Neusha, can you tell us when a duty of care might be established in tort?
Sure. So you may be aware of the decision found in the well-known case of Hardiman and Heller, which established that in limited circumstances, where a party is seeking information or advice from another possessing a skill or is a professional, and trusts that skilled party to exercise a duty of care when giving that advice, and that professional knew or ought to have known that party one was relying on its skills and judgment and gives that advice without qualification, a duty of care will be imposed. This gives a party the right to claim in negligence and, importantly, seek damages for pure economic loss. Hardiman opened up a cause of action outside the law of contract for loss based on reliance on a statement. That was nearly 60 years ago now, and since then, the application in its application has been various variations in it. So I'm just going to refer to a judgment that's on the screen now, Caparo and Dickman. The House of Lords in the case of Caparo and Dickman established 3 requirements to be found before a duty of care could be established. Lord Briggs said, the salient feature of all of these cases is that the defendant given advice or information was fully aware of the nature of the transaction which the plaintiff had in contemplation, knew the advice or information would be communicated to him directly or indirectly, and knew that it was likely that the plaintiff would rely on the advice or information in deciding whether or not to engage in the transaction. In the more recent case of Burgess and Legervarn, it was alleged that an architect had acted negligently whilst given advice to some friends free of charge. There was no contract formed between the parties. Whilst there was no contractual duty owed here, the architect owed her friends a duty of care in tort because they were clients in a professional sense. She possessed a special skill. Any work done had to be provided with reasonable skill and care, and therefore she had assumed a responsibility on which they had relied. In all of these cases, you'll notice there is a requirement for the advice giver to possess a special skill. Therefore, it's often in cases where consultants such as architects, surveyors, and engineers advise and subsequently get it wrong, where a duty of care may be assumed.
Okay, so that's going to be a bit concerning for any professionals on the webinar. Are there any circumstances where an assumption of responsibility is unlikely to be established?
Well, the starting point to remember is it was held in Robinson and P.E. Jones that a contractor who solely undertakes building operations as opposed to design work is unlikely to assume a responsibility in tort.
Okay, yeah, so let's go back to the professional consultant or some other party undertaking design work. Can you talk about that?
So in that case, I think the most recent and leading authority on assumption of responsibility is the multiplex case. And that's where the TCC considered whether an independent design checker owed a duty of care in tort to protect the main contractor from pure economic loss.
Okay, I'm going to ask you to summarise the background facts of the case, but people on the webinar will be able to see a diagram showing the sort of the contractual relationships and also the citation of the case. But if you go into the background facts first, Neusha.
Sure. So the claim concerned a substantial construction project of number 100 Bishopsgate in London. Multiplex was the design and build contractor. It engaged a subcontractor, formerly known as Dunn, for the design and construction of, amongst other things, the concrete package works, which included a slip-form rig used to construct the concrete core. The subcontractor subcontracted the design of the rig to BRM. the subcontractor also appointed a professional design checking consultancy, R&P Associates, to perform what is known as a Category 3 design check and thereafter issue certificates. The certificates were required under the British standard, but also under the terms of done subcontract with Multiplex.
Okay, so something's gone wrong and there's no contract between Multiplex and R&P, but Multiplex has got its whole contractual chain set up. So why go for R&P when it looks like it's got an easier contractual route, both Dun and BRM?
Well, Dun sadly went into administration, and so Multiplex had to appoint an alternative subcontractor. That subcontractor, the Byrne brothers, found defects in the slip-form rig, which was subject to R&P's checks. They considered part of the rig to be unsafe, and so work couldn't continue until the rig was replaced. Also, both BRM and Dun were insolvent and uninsured to cover the losses. Whilst R&P was also insolvent, it had insurance to cover the losses. As a result, despite there being no contract between Multiplex and R&P, Multiplex alleged that R&P owed it a duty of care by way of assumption of responsibility in respect of its design check of the rig and the issuing of the certificates. It therefore brought a claim against R&P's insurers for the pure economic loss it suffered.
And so what happened in the proceedings?
Well, the issues to be considered were twofold. First, whether R&P owed Multiplex a duty of care in tort in respect of the checking of the design of the rig and also the issuing of the certificates. And secondly, whether R&P had provided warranties directly to Multiplex by way of the certificates. Multiplex argued R&P did assume responsibility as it knew or ought to have known that its checks and certificates would be relied upon by Multiplex.
Okay, so I understand that the judge, who was Mr. Justice Fraser, then considered the tests for establishing assumption of a duty. Can you talk us through some of the factors he considered and the decision he reached?
So it first needed to be established that R&P owed Multiplex a duty of care, but also that any duty that was owed to Multiplex by R&P was sufficient to encompass economic loss. If there was no duty of care established, then further consideration was called for by way of a three-part test. There also needed to be legal reliance in terms of linking the damage suffered to the breach of duty. Mr. Justice Fraser held that R&P did not assume responsibility for the statements in the certificates in applying either the first test or the three-part test. In considering whether there was an assumption of responsibility, some key factors were considered by the TCC, and there was more than 15, I think, but I'll just summarize a few of them. So the fact that there was, in Mr. Justice Fraser's words, a consciously created framework of contractual relationships, and R&P owed contractual obligations to Dun and not Multiplex. A finding of no duty of care would not leave Multiplex without remedy, as it had contractual and tortious claims against a subcontractor. The subcontractor's financial position was not a factor to consider in the interest of justness and fairness. And finally, R&P had not provided advice to Multiplex, but provided the certificates directly to the subcontractor. Mr. Justice Fraser held, putting aside the issues of foreseeability and proximity, it would not be just, reasonable, or fair to impose a duty of care of the type contended for by Multiplex on R&P.
Okay, just for completeness, you did mention earlier that there was a question the court has to consider about what the documents themselves said and what their effect was. Can you just tell us about that?
Yeah, so Mr. Justice Fraser found that the wording or content of the certificates did not mean that R&P had given any warranties. He commented, it would go entirely outside the detailed contractual framework to construe statements by R&P within the certificates or the certificates themselves as constituting warranties given directly by R&P to Multiplex.
Okay, Neusha, it's a pretty complicated case, I think, isn't it? Can you just give us a high-level summary before we move on?
Yeah, so Mr. Justice Fraser stated imposing a duty of care from a Category 3 checker to a main contractor would have potentially serious consequences, and therefore on the evidence concluded that R&P had not assumed a responsibility to Multiplex. Multiplex chose to contract with Dun on highly detailed terms. It had a cause of action against Dun, and there was no liability gap, so it would not be left without a remedy, absent of a finding of duty of care on the part of the consultant. A detailed contractual structure governed the relationships between the employer, contractor, and subcontractor. The consultant's relationship with the subcontractor was outside of those contractual relationships, and to find that it had assumed a responsibility to the contractor would short-circuit them. This judgment highlights the importance of the complex contractual framework in these types of multi-party construction projects and the importance of obtaining collateral warranties or possibly the granting of rights under the Contracts Rights of Third Parties Act at the outset of the project. Establishing a duty of care in a context like the multiplex case between a main contractor and a consultant where there is no contract in place will prove extremely difficult.
Okay, thanks, Neusha. I mean, that's a really good example where a duty is unlikely to be established. And of course, on the line there with you, where you've got the crossed out dash, if that was replaced by a collateral warranty, we'd have had a totally different question being asked of the court, because then there would be a contractual link. Anyway, we want to talk about some other circumstances. Sophie, can I just ask if there are a couple of circumstances you can provide examples of where a duty is likely to be established?
Yeah, so there's a couple of examples on the slide where a duty of care is unlikely to be established. The first is if someone else has assumed the risk and it's covered by insurance. So in the case of Norwich County Court and Harvey, the Court of Appeal dismissed a claim by a building owner against a roofing subcontractor for damages for negligently caused fire damage. Both the owner and the subcontractor had contracted with the main contractor on the basis that the owner had assumed and would insure against the risk of damage by fire. And in those circumstances, it was not fair, just, or reasonable to impose a duty of care in tort to avoid such damage on the subcontractor. The other example is where there is specific limitation in the contract between the consultant and the contractor. So in the case of Belfield Computer Services Limited and E. Turner and Sons Limited, the architects owed no relevant duty of care because of the way in which the scope of their design obligations was limited by their contract with the main contractor.
Okay, can you give us a couple of situations where maybe the duty of care is established, but it is limited in some other way?
Yeah, so again, there's a couple of examples on the slide. So a duty of care that is established will be limited by the extent of the claimant's foreseeable reliance upon the advice or information which the defendant provides. And that was discussed in the case of Liddell Properties and Clark Bond Partnership, where at a meeting, the defendant gave advice about the costs of decontaminating a site. And whilst it was found that the defendant had a duty to provide that advice with reasonable skill and care, the purpose of the meeting was to allow the claimant to form a view of the costs of the defendant's proposed decontamination of the site. So the defendant couldn't be expected to give a full history of the site in that meeting, and in any event, the claimant did not rely on the advice given, so the case was dismissed. Another example is where it could only be expected that the advice would be relied on for a certain period of time. So in the case of Payne and John Settle Limited, certificates were given that were similar to an NHBC warranty, and it was found that it was only foreseeable that those certificates would be relied on for 10 years, which is the period that NHBC warranties usually last for. So now I'm going to turn the tables and ask you some questions, Ben. As always, whilst the law is important, we're conscious that the practical reality on the ground is what people want to understand. So I wanted to ask for a couple of your top tips. Firstly, is there a one-size-fits-all answer to this?
No, I'm afraid I don't think there is. I mean, as you can see from the cases that you and Neusha have discussed, there are nuances in any project, and that gives grounds for argument. And so I think to some degree this depends on where in the contractual chain you sit and what you do. If you simply build, it's very unlikely that you're going to assume a duty to any third parties. However, designers, architects, engineers, and others who possess that special skill, which could be relied on, are clearly more at risk of assuming a duty to someone with whom they may not have contracted.
Okay, and uncertainty is never a good thing. So is there anything the professional team in particular can do to limit that uncertainty?
Yeah, I certainly think you can improve the protection that you've got by ensuring that you have a clearly defined contractual chain. Multiplex shows that if that exists, the courts are going to be reluctant to step outside of it and impose additional duties of care that have not been allowed for in the contract. via tort. Now, it's stepping slightly outside of the scope of the tort, but I think the importance of getting that contract right just can't be underestimated. And there's a couple of reasons for that. Firstly, you may have the opportunity to limit the extent of your responsibility in the event something goes wrong. So, for example, a cap on liability or a net contribution clause. Secondly, you may well have made representations to your insurer about the way in which you set up your contractual structures, how you manage risk, etc. And finally, depending on your profession, you may well have a regulatory obligation to do this. So the ARB, for example, is particularly hot on this. When I last checked, 8 of the last 10 reported decisions in terms of their investigations into the conduct of their architects involved a failure to provide adequate terms of engagement.
Okay, so that's really interesting. So let's assume we get the contracts in place. Are there any other practical recommendations you can give about what to do whilst the project's ongoing?
Yeah, so the 4th bullet point on the screen, I've put a reference to scope creep, or sometimes called mission creep. I think this is a really difficult one to deal with in practical terms, but if you've agreed to do a certain set of services, try not to go beyond them and carry out additional services that you haven't agreed to do, but also you haven't been paid to do. Don't provide advice or assistance to parties with whom you've got no express contractual relationship, or you risk assuming a duty to them. Multiplex is a really good example of that. RMP did not provide the information to Multiplex. They weren't assuming a duty to them. I know from practical reality, from speaking with clients about this can be really, really difficult to do in practice. You don't want to be the difficult party responsible for stopping or delaying the project. But if you do have to provide information, try to do so in writing. Try to include a clear qualification that you're not assuming legal responsibility for doing so. I appreciate that looks contrived, but you may well be very grateful for that email if things go wrong and a claim lands in the future.
Yeah, so you mentioned if things go wrong on the project, and hopefully for the majority of the people on the webinar, it won't. But are there any risks if things do go wrong?
Yeah, as I say on the slide, I think just be careful of what you do and what you say. So you can bet your bottom dollar that if a problem arises, the claimant's legal team are going to scrutinise everything that's been said. So if you offer to help to sort out a problem that wasn't of your making, that may well indicate that you were aware that you had a responsibility to it, and therefore that links to whether you thought or believed you may have had some sort of responsibility in the first place. Secondly, and for similar reasons, if when the complaint, the grumble, the claim lands, anything you say which is inconsistent with what the contract provided for, that may well be used against you as evidence of accepting a wider responsibility.
Okay, great. Thanks, Ben. So that's about all we've got time for. So we'll just have a look and see if anyone's got any questions. Okay, we do have a couple. So the first one is, if someone has a right to bring a claim in contract, is there any reason why they might be concerned about establishing a duty in tort? Are you okay to say that, Ben?
Yeah, I can. So I think it goes back to what Sophie said at the start. If there's a contractual relationship, a duty of tort will coexist with that in contract. But the existence of the cause of action in tort may still be important. So, for example, we know that defects in construction contracts are often latent. They may not be discovered for many years, by which time a claim in contract may be statute barred, particularly a claim under a simple contract, 6 years to bring that. And where tort may step in is where it offers the date of knowledge under Section 14A of the Limitation Act to give three further years to bring a claim from when that problem is discovered. And that might give an alternative route or cause of action to recover damages, even if that more straightforward route may no longer be available. Sophie, there were a couple of other questions specifically about multiplex around that contractual makeup and whether there was a collateral warranty, whether step-in rights might have existed. I'm not sure. Well, neither existed for the purposes of the decision, which is why Multiplex were reliant on establishing the assumption of duty. So that addresses those issues. Sorry, I failed to move on the slides there. We hope you've enjoyed that talk. We are at the end of it. What we're going to do following this, we will send copies of the slides to you in due course. If you have any other questions, please do quickly drop them in now. We will try to respond by email afterwards. We do send out a feedback questionnaire. Please do fill it out. We really value the input that you provide. And of course, if you do give us any examples of sessions you'd like to hear from, we will do what we can to build a talk around that. One to look out for, next Breaking Ground is the 21st of March. Nick Oldham, Nathan Jones and Tim Russell will be discussing claims for contribution and how the court might apportion damages. Watch out for an email invite dropping in your inboxes next week. Thank you very much for listening.